Okay, so welcome back, everybody. We are having our last formal Zoom session this evening. So the last topic that we're covering is the trial. And it's kind of difficult to, lecture something that ideally we would have been doing in a practical exercise in class. And you would have seen the video that I posted to the WhatsApp channel. We would have undertaken a similar exercise in class. Um, Obviously, having done this lecture and series of lectures on the trial, just to give you a feel for what is involved in conducting and running a trial, how to make opening statements, how to introduce witnesses, how to do examination in chief, cross-examination, re-examination, how to do closing arguments, and that sort of thing. So to put what we're saying today in the slides and the audio and in the session, to give you a feel of the practicalities of what any and all of this means, please watch that video. Uh, it's it's a mock trial, part of the mock trial competition where all universities or most universities participate. UKZN used to participate as well up until just a few years ago. Um, and we tend to have pretty good showing. At the last competition, we placed second, and that was the team from Maritzburg. So we did very well. I think we did better than the team from Durban. So the Maritzburg team did very well there. But it's just to give you an idea of how the process would unfold in court. And this is essentially, the trial is the culmination of everything. In other words, we've been building up to this point. So criminal procedure, as we now understand it and now we know, is that it's not just what happens in the courtroom. There's so much more preparation, evidence gathering, etc., investigation involved to bring us to the point, the prosecutors to the point where they can now bring the matter to trial. And we covered last week, we looked at the charge and we looked at pleadings. And so the trial then begins once the pleading stage is over. So once the accused is said to be arraigned and has pleaded, then what everything that we've covered in the slides and audio and the notes for this week is what transpires. Ending, in a sense, that this process can end at verdict. So at the end of the trial, when the court pronounces whether the person is guilty or not guilty. Now, there's various processes involved and rules of court which must be followed, and we'll talk about those as we progress as much as we can. So there's a purpose to having a trial. And when we consider the Constitution, and remember we said we talk more and more about constitutional criminal law and constitutional criminal procedure and constitutional trial procedure. And we've covered those as various aspects of constitutionality. The trial then is the consideration of all of those aspects, right? And when you're leading evidence, whether you're leading evidence that was constitutionally obtained, whether it is hearsay, etc., and that's the type of stuff that you would have covered in your course on evidence as well, admissibility thereof. When we looked at pleadings, the different types of pleadings and why, for example, article acquit and article convict are constitutionally sound. In the trial itself, could an accused person raise that the evidence, fingerprints, voice samples, bullet DNA, whatever, was obtained unconstitutionally, in that it was a violation against his right to self-incrimination? Now, these are real questions that could certainly very well present themselves in court in what we would call a trial within a trial. So all of those aspects are in fact important as forming part of your arsenal and knowledge on how one proceeds with a trial and what can and should be argued. So the trial itself then is, if you think of the rule of audi alteram partem, in other words, that both sides, hear both sides of the story, or hear both sides, the story about what transpired, what happened. That is where the criminal trial comes in. So it would be certainly unfair, to say the least, and absolutely unconstitutional if all of this evidence was gathered and without hearing the other side, a prosecutor or whoever is sitting with this docket or all of this evidence makes a pronouncement. And the evidence is not tested in open court. What would that mean for due process? What would that mean for crime control? What does that mean for procedural fairness or procedure at all? Okay. So we look at the various principles, and you can listen to it and see how everything that I've just in brief spoken about what that means in this context. Now the trial itself has a procedure. So remember we said that you can only play a game if you know the rules, and you can only play a game better, well, or win the game if you know the rules better than the other person. But knowing the rules and knowing the rules better doesn't necessarily mean that you are able to perform. And this is where, if you're thinking about a game as being a game, the more you practice actual physical practice of the playing of this game, the more skilled and adept you will become at those practical aspects involved in the trial. And here we're talking about how to lead evidence, how to conduct examination in chief, how to conduct cross-examination, how to conduct re-examination, how to prepare and deliver closing arguments, and those sorts of things, right? So after the accused person, and we're working on this, the steps that we're going to be considering begin on the premise that the accused person has pleaded not guilty. Not guilty. In other words, what this means is that he denies having committed the offense or part of the offense, whatever the case may be. But let's just say that he denies having committed the offense and now puts the state to prove it. The state must prove it. And when we say prove it, in criminal law, we mean that the state must prove all of the elements of the crime. In relation to what? In relation to the factual scenario and the evidence it has gathered to support its conviction or its claim that the accused person is legally and factually guilty. So once the accused person has pleaded not guilty, the state opens its case. And this opening of the case means that the state gives a brief summary of the facts and what it intends to prove. Then says it's going to call its first witness. And the witnesses, or the order of the witnesses that the state chooses to call, are usually the strongest witnesses first. In other words, those that can do most for your case, and it may also transpire later that it's not necessary to call any of the other witnesses. But for the state side, there's no preferred order, whereas with the defense, the prescribed order is that if the accused is going to testify, he must testify first. And there's a good reason for that. We'll talk about that a bit later. So the state calls its first witness, and then this witness has to give testimony. And this testimony is the evidence that is going to be tested, and that is when evidence is actually before the court. Now, examination in chief serves many purposes. The most important one is that it puts forward under oath the state's version of events, the state's version of events. And when we say that, what we're actually meaning is that the witnesses called for the state must, through their testimony, show that all of the elements of criminal liability for that particular crime have been satisfied. Now, examination in chief, if we understand it as the telling of a story or the telling of a version, and at this point uncontested, because the defense hasn't engaged in examination in chief, in cross-examination yet. So the examination in chief of all of the state witnesses, whether it's one or two or more, serves the purpose of creating a prima facie case. That without anything else said, here are our witnesses who have now on oath, in a sense, confirmed or proved rather that the accused is guilty because all of the elements have been satisfied. How do you conduct examination in chief? Well, we call it leading the witness, but that's kind of confusing if we think that, well, but I'm not allowed to ask leading questions in an examination in chief. Leading must be understood as a form of a guided narrative. So as much as the witness is giving their story or their version of events, as the prosecutor or the attorney who is conducting examination in chief, this must be guided. So with questions to prompt or direct rather the witness's testimony to deal with those issues that ought to be canvassed. Now, where would you get this material for examination in chief? Well, it's your witness. It's your witness. So you would have had the opportunity to interview the witness, recognize them, go through statements, and canvass with them in a devil's advocate sort of way what possible cross-examination questions could exist, and test then the reliability and viability of this witness's version of events. Following me so far? Now, as much as you have access to your witnesses, you may not have access to the defense witnesses or the accused themselves, in that you would not be able to sit down and identify them and run a version of cross-examination with them. But you do have the docket and whatever police statements were taken in relation to the investigation, and whatever else has been gathered and is now available in that file. So you would be testing and being able to gauge what possible defense the accused is going to make. And you would be canvassing that in examination in chief. Now, the next step, we're still dealing with the first state witness. So once examination in chief is completed, before the prosecutor says that he or she is done with that witness, no further questions, must take a moment to consider whether I have got everything I intended to get out from this witness. So even examination in chief must have a particular goal. One witness's value may be, or the most pertinent thing that this one witness is meant to add to your case, is that they saw the accused stab the victim, right? They saw the accused stab the victim. Now, if that is the one crucial piece of evidence that this witness is meant to have had put forward to the court, you must ensure that your questioning has brought that out, that the witness has said, and further that the witness was able to point out or deal with various parts of police investigation that the witness successfully identified the accused, or that the witness sees the accused in court today and identifies clearly. And once that is done, the state prosecutor will sit down, and now it's the turn of the defense. Now the defense hasn't opened its case yet. It is simply now conducting cross-examination. What is cross-examination? So if we think of, what types of questions aren't allowed in examination in chief? We said leading questions are not allowed. What are leading questions? Leading questions are those questions which suggest the answer. So, was he wearing a red shirt? Yes, he was wearing a red shirt. That's a leading question. Versus, can you describe the types of clothing that the accused was wearing on the day in question, or at the time of the? That's not leading. Okay. Now, why we bring that up is because the difference with cross-examination is that cross-examination doesn't have that rule. Any questions, leading or otherwise, can be asked under cross-examination. Any types of questions. Okay.
Can I just ask?
Yes.
The reasoning behind that rule.
Which rule? No leading questions.
That no leading questions when it's chief examining.
Because the version of events must come from the witness. It mustn't be that the prosecutor, who is far more skilled at law, right, and knows what is required to find guilty or not guilty, testimony mustn't come from the prosecutor. And if questions of a leading nature are asked, what testimony actually has the witness given? Do you understand what I'm meaning?
Yes, ma'am.
But at the same time, it doesn't mean that all leading questions are objectionable. Now, where the leading question, or where the question deals with a matter of merit or matter of significance and of contestation, those will be objectionable, right? Objection, and the court will tell you to rephrase the question. Now, you've already prompted the witness as to what the answer would be. So no matter, unless your witness is completely off, no matter how you rephrase the question, the witness is already prompted to the answer, right? I was going to say something else. Yeah, so some leading questions are allowed. And certainly when you're leading your witness in examination in chief, you also want to have some questions that can put your witness at ease, make them feel comfortable, a little less stressed, and get, comfortable with what the process and what's going on in court. And so things like, what is your name? Are you male? Are you female? Those sorts of questions, which are not in contest, right? There's no dispute. Leading questions would be permissible. So also what type of leading question it is also important. And you develop the skill, the more you watch court cases, the more you participate, in trials. And the next, so what evidence in chief is meant to do? It's meant to build a wall. Brick by brick, it builds a wall, creating this prima facie case. Now, cross-examination is meant to poke holes in this wall, thereby creating doubt. And so cross-examination also has a goal, also has a purpose. And the purpose would be to refute, test, and contest the state's version. And so as the person conducting cross-examination, you also have a goal. What damage did this state witness do for the defense version? And are their questions relevant and witnesses that the defense will call later that will oppose or counter those that version. So in cross-examination, not only it's certainly more than just making the witness feel uncomfortable, right? It's about testing their version against the defense version when the defense brings its witnesses. And so, although the defense witnesses at this stage have not given evidence in chief and have not testified, they will, and you know which of your witnesses you're going to call, and you know which of them you're going to say. And so you would say to this witness, for example, who has said, now I saw the accused on the night in question. The accused intends to defend and give testimony when he is called as a witness for the defense case. And his version is going to be that you can't possibly have seen me because I was out of town. Okay, maybe he's got an alibi. So you'd have to test that. You'd say, well, in examination in chief, Mrs. Jones, you said that you saw the accused on the night in question. Yes, that's correct. That's what I said. But I put it to you that perhaps you were mistaken. Because the accused, when called to give evidence, will say that he was, in fact, out of town. How do you react to that? Now, most witnesses will say, no, I know what I saw. I know what I saw, and I know who I saw, and I'm not wrong, I'm not lying. So what does that mean for your case as the defense? The witness having given her a version as, no, I know what I saw, and that's him, that's definitely him, he's the guy I saw. It hasn't. Provided, of course, that the accused does come to give a testimony, does stand up to give his testimony, at least now it's put before the court in an early stage before the accused has had the opportunity to give his testimony. Because when he does stand up and say, look, here's my tickets, here's my flight details, here's a photograph of me sitting on the beach on that day, whatever the case may be, it mustn't be that is the first time that the court is hearing it, right? It's been tested early enough against the state's version of events, right? Cross-examination. After the defense is done with cross-examination of this state witness, again, ask yourself, have I elicited, have I gotten what I wanted to get out of this witness, and have I created doubt? But most importantly, have I put the defense version to this witness such that it may be tested? That is the most important thing. It mustn't be that at later, only when the accused or the defense witnesses come, that this version of events is the very first time that the court is hearing of it. Because then the court will draw inferences, certainly negative inferences, particularly that this version is concocted or fabricated, right? And then the state gets an opportunity again to conduct re-examination. Now, re-examination again has very particular rules. And the questioning coming from re-examination is based on the questions and answers brought about in cross-examination. No new matters can be raised. New matters can be raised. And so where we started off by saying that examination in chief builds a wall, cross-examination makes holes in the wall, right? Re-examination attempts to plug up the holes. Okay. And once the state has gone through, and the state will do this for each, and this is the process for each of the state witnesses. And it's a similar process for each of the defense witnesses, right? So once the state is done, it will close its case. Now the defense has an opportunity. Now, the defense can either decide to open its case and lead evidence. Alternatively, it can ask for a Section 174 discharge. Now, Section 174 discharge is basically without, so you've put a version of events to state witnesses, but you've not yet called any of your own witnesses. Despite this, you believe that no prima facie case has been made, and you now demand a verdict without leading any further evidence. The court can accept and offer a verdict, and it could go either way, guilty or not guilty. Or it could say, no, I'm not satisfied. Go ahead and lead your witnesses. At which point, then this same process unfolds. Examination in chief, cross-examination, re-examination for each of the witnesses. And once both parties are done, have called all of their witnesses and led all of their evidence, it's now what we call closing arguments or final arguments. And the prosecution gives its closing arguments, the defense gives its closing arguments, and then the prosecution has an opportunity to reply to points of law or other points for clarity raised by the defense. Okay, and then a verdict is given on the merits, and that verdict could be guilty or not guilty. Sentencing then can happen in the same court or to another court, depending whether the court feels that given the nature and gravity of the offense, a higher court would be better suited to give a more suitable and more strict punishment. So what I've put out is then just the course of the trial in more of a step-by-step format. And I want you to, when you're watching that video, bear these in mind so that you can see how it unfolds. All right, so that's pretty much all I have to say about the trial. It's difficult to do a practical lecture like this, but I think that video that I've put up for you on the WhatsApp group will greatly assist in seeing how that transpires. Any questions on the trial? No.
No question for me. I'm just really sad that we couldn't do this class.
It was, every year we do it, and every year it's a hit, the mock trial. You guys get your dossiers. We make 2 teams, actually 3 teams. One team's the magistrate, one team's the prosecution, one team's the defense, and then different members in the class get to play the role of the accused, witnesses, and stuff like that. It's really a fun exercise, and it's just a pity we weren't able to do it. It's really fun, but yeah, I mean, at least you've got a video from which to see how that would have played out. Okay, so guys, this is our last formal Zoom session. All of the material examinable has now been covered. The assessment 2 will be available to you guys this evening at 8 o'clock, 2000 hours military time. Okay, and we will meet tomorrow evening via Zoom at 7 p.m. So use the link on the Moodle page and join in. So you've got, call it 23 odd hours in which to look over the questions and see, what you require clarity on. Of course, it will be on form rather than substance. But as we did with specific offenses, it's pretty much the same sort of quick 15-minute meeting where you can just iron out any concerns or questions or queries in relation to the assessment. All right, so I will see you again tomorrow evening at 7 p.m. via Zoom. Okay.
Thank you.
Okay, so all the best, and I'll see you all tomorrow evening. Thanks so much.